Bueno, muy buenos días. En nombre del Servicio Nacional de Derechos Intelectuales de Ecuador, de Corporación Innovarte y del Washington College of Law de la American University, le damos la más cordial bienvenida a la última jornada del segundo ciclo de conversaciones sobre derechos de autor y agenda internacional. Este es un espacio de encuentro donde desde el día de ayer hemos estado conversando temas orientados a colaborar con la creación de un sistema de derecho de autor justo y equilibrado que apoye la creatividad y promueva el interés público. Al igual que ayer, entregamos un cordial saludo a todas y todos los presentes, especialmente a quienes nos acompañan como autoridades y representantes de diversos países de Latinoamérica. Aprovechamos la oportunidad de comentarles que este evento cuenta con traducción simultánea inglés-español en todo momento. Por ende, invitamos a quienes quieran acceder a esta traducción a activar la función establecida en la barra de herramientas del Zoom. El encuentro de hoy se dividirá en dos secciones. En primer lugar, abordaremos las propuestas relacionadas al entorno digital, la propuesta de Senegal y el Congo para incorporar el derecho de participación y la propuesta de un estudio centrado en el derecho de préstamo público. Y en segundo lugar, tendremos para finalizar una sesión reservada solo para representantes de oficinas y gobierno. Por lo que una vez finalizada la actividad anterior, se les solicitará a los representantes de la sociedad civil que se pueda desconectar del Zoom para dar inicio a esta sesión reservada. A continuación, dejo con ustedes a Luisa Suyay Torres, directora general del Servicio Nacional de Derechos Intelectuales, SENADI, de Ecuador, quien nos dará sus palabras de bienvenida.
Gracias, René. Muy buenos días con todos. Bienvenidos sean a la segunda jornada de derechos de autor que se está desarrollando. Gracias al apoyo por todas las oficinas, a Innovarte en particular, SENADI como gestor también de esta iniciativa, da la bienvenida a todos, a los miembros del GRULAC, autoridades y al público presente en general. Demos inicio entonces al segundo día y a las propuestas que se han detallado por parte de René. Bienvenidos todos.
Agradecemos las palabras de la señora directora general Luisa Suyay Torres. De esta manera, entonces, estamos comenzando con esta primera parte, que es ver y analizar y escuchar los comentarios de la sociedad civil sobre el punto de la agenda del Comité Permanente de Derecho de Autor y Conexos CCR, su sigla en inglés, de la Organización Mundial de la Propiedad Intelectual, y que dice relación con propuestas que aún no tienen consenso para formar parte de la agenda principal. Esta sección será moderada por Beatriz Busaniche, quien es directora de la Fundación Vía Libre de Argentina. Estimada Beatriz, le cedo la palabra.
Raúl, Beatriz está teniendo un problema técnico de ingreso y eso le da más suspenso.
Les voy a reenviar el link. Espérenme.
El-
Se lo reenvié a su correo. Esperemos que lo pueda ver.
Bueno, mientras Beatriz se conecta, la vamos a ir cubriendo. Entonces, el panel que vamos a comenzar hoy día, tenemos la presencia de dos expertos y consultores, asesores en materias de propiedad intelectual, particularmente al área de las bibliotecas, que son el señor Jonathan Ban y Teresa Hackett. Teresa Hackett es la directora de la ONG Internacional EIFL, que es Electronic Frontier for Libraries, y Jonathan Ban, quien es abogado, especialista en propiedad intelectual y tecnologías, y particularmente asesora al American Library Association. Teresa, you might begin.
Okay, thank you very much, Louise. Thank you for the introduction. And I'm going to just briefly now share my screen, if I may, and I hope that you can all see that there. All right, so can I just get the thumbs up that you can see my screen? Perfect, thank you very much. So thank you, Louise, for the introduction, and thank you very much for the kind invitation to attend this meeting discussing the important topics that are coming up at the SCCR in Geneva in a couple of weeks. And since this is the first SCCR that has met in person since the start of the pandemic, I think we're quite excited to get back to Geneva and to have the opportunity to meet with delegates in person and to discuss all of these issues. So today, myself and Jonathan are going to talk about the agenda item 9 on the SCCR, which is entitled Other Matters. Now, on the agenda item 9, there are 4 proposals. The first proposal is a proposal for analysis of copyright in the digital environment that was made by GRULAC in 2015. The second is a proposal from Senegal and Congo on the resale right. The third proposal is from the Russian Federation on the rights of theatre directors. And the fourth proposal is for a study on public lending right that was made by Sierra Leone and then later on joined in the proposal by Malawi and by Panama. So I think to start out, we could say that in general, our position of civil society on these issues in other matters is to try to finish the other agenda items before we introduce new topics into the main agenda of the committee. So we would appreciate and value making progress on the limitations and exceptions in accordance with the 2012 mandate, because we think it's important to maintain that time on the committee's agenda for the outstanding issues connected with limitations and exceptions after the Marrakesh Treaty. And these exceptions, which I think you've heard about yesterday, are for libraries and archives, for education and research, and then other disabilities that were not covered by the Marrakesh Treaty. And we have a very interesting and I think exciting proposal by the African group for a work plan on limitations and exceptions that has some interesting proposals on how we can move forward with these topics. In addition, the COVID pandemic has highlighted some of the problems that were already being discussed under these agenda items, especially online education and access to digital resources in libraries that we saw was problematic during the lockdowns when the physical buildings were closed. So, but one approach to take with this agenda item might be that we deal with the proposals in the order in which they were made. So if we want to address some of these items that are coming on the committee, that might be one approach. And if we took that approach, then the first proposal would be the proposal for an analysis of copyright in the digital environment by GRULAC. So this was the earliest proposal made in this agenda item. And just as a brief reminder that the objectives of this proposal were threefold. The proposal was looking to have an analysis and a discussion of the legal frameworks used to protect works in digital services, primarily relating to music, not exclusively, but the focus was certainly on music. Then to have a discussion on the role of companies and corporations that make use of these protected works. In particular, to look at the transparency on the business models and the transparency on the payments that are made to creators and artists. And then the third area was to build consensus on the management of copyright, and in particular, looking at the low payments that musicians and creators are getting in this environment. So the activities so far that the committee has done relating to this proposal are that they have produced a number of studies on the global digital music market. So some general studies, and then also some studies related to particular regions, including the Latin American music market. And at this SCCR, the Secretariat and the authors of those studies will provide an overview of the work that has been done on this topic. And then the chair will invite member states and NGOs to make comments and to give their inputs on the next steps. So we would suggest that a suggestion would be to deal with this topic would be to propose work on aspects that have not been examined so far in those studies that have already been done by the Secretariat. So for example, to look at the area of revenue distribution and the role of intermediaries and transparency in the distribution of revenue. To look at the aspect of the low payments to music artists and to creators, and to unfair and anti-competitive practices in this space. So if I remember, those issues were like kind of at the heart or at the core of the proposal that was made by GRULAC. So it would be good to see those issues addressed and examined in more detail by the committee. And these are, of course, global issues. They're affecting musicians and artists all over the world, and also consumers as well, who want to do right and to be fair to artists and creators and musicians. So the next proposal that I will look at, it's the most recent proposal on this agenda item, which is a proposal for a study on public lending right. Now, public lending right, or PLR, provides a royalty to authors and other rights holders like publishers for the public lending of books by libraries. There are three ways in which public lending right can be implemented: as an exclusive right under copyright law, or as a separate remuneration right, or as a state support for culture, so part of a country's cultural policy. And it's about 35 countries around the world have working PLR systems. Mostly in the European Union, it's mandatory in the European Union, and then we have Australia, Canada, Israel, and New Zealand. There are a number of other countries that have PLR on their statute books, but to our knowledge, they are not yet functioning. Now, the IFLA, the International Federation of Library Associations and Institutions, and the international library community, including my own organization, do not favor the principles of a lending right because it can jeopardize free access to the services of publicly accessible libraries. So we believe that there is a threat to free and equitable access to services provided by libraries. There are particular challenges in developing countries. In fact, in the 1990s, WIPO discussed PLR, but they rejected it because of the negative impact it would have on libraries' literacy and development in the global south. And our concern is that if PLR is implemented through copyright, one of the legal basis for PLR is that, of course, national treatment would apply. So that would mean that we would risk that the monies collected from libraries or from the the government would not stay in that country, but in fact would flow to other countries, in particular to the global north, where many of the big international publishers are based. So what will happen at the SCCR? Well, similar to the GRULAC proposal I mentioned earlier, the chair will invite the proponents of this proposal to give a brief update, and then we'll invite member states and NGOs to make comments and give inputs on possible next steps. Now, our recommendation would be that, that members could support the library community. And our suggestion would be that this issue of PLR is not a WIPO issue, because there is no international public lending right. It's not a cross-border issue, and it is really, in essence, a form of cultural policy. There is a risk placing the topic within copyright, as I mentioned, because of this national treatment that would apply. So it's quite complex and may have unintended consequences. And if we do want to discuss the issue of compensation for authors, UNESCO, for example, might be a more appropriate forum to have such discussions, because then you can discuss all of the issues holistically and not only from the copyright perspective. So we would recommend that the committee should not engage in spending time on having a study on this issue at WIPO. But if there is to be a study, it must take this holistic approach, looking at all of the different ways that authors can be supported, and indeed are supported in many countries, like tax breaks for authors, direct grants to authors, which would be, in our view, way more efficient and effective, because it's not you don't have to set up a whole PLR system, and you're not involving intermediaries like CMOs, who will of course take a cut from the monies collected from libraries. So any study should look at the costs of a PLR as well as any perceived benefits. It should look at the disadvantages as well as the advantages. So after that brief introduction to those two proposals in the agenda item, I'm now going to hand over to Jonathan, who will talk about the other two remaining proposals. Thanks, Jonathan.
Thank you very much, Teresa. Unfortunately, I don't have slides, so you'll just have to listen to me and I guess look at me. So the other two agenda items, as Teresa outlined, one has to do with a artist resale right, and then the second one has to do with stage directors. So we'll go in order. With respect to the resale right, so what is it? This is actually something that many countries in Latin America have. It is the notion that an author or a creator of, let's say, a painter, someone who creates a work of visual art, receives a royalty every time that unique work is resold. So again, a painter paints a painting, he sells it, and then every time that painting is resold, he would receive a percentage of the proceeds from the sale. The theory behind that is unlike other authors in copyright, let's say someone who writes a book who can receive a royalty every single time a copy is sold, and if he becomes more popular, more copies get sold, he makes more money. Unlike that situation, the artist, the visual artist who paints a painting or some other kind of unique work, after he sells it the first time, he would not receive any benefit unless there was some kind of resale royalty. So there is this approach. It was first adopted in France, and that's why it's called droit de suite. It's a French name, but it has since spread to other countries. So there is a European Union directive that mandates a resale royalty throughout Europe, and many other countries, especially in Latin America, have also adopted it. And so the idea here is, and also some African countries. And so here, African countries did put it on the WIPO agenda. And there have been several studies. The main problem for a droit de suite advancing in WIPO is that it is strongly opposed by the United States and by other countries with more of a common law tradition. So in the United States, for example, we have this very strong doctrine of exhaustion, or we also call it the first sale doctrine. And that's once a copy, a lawfully made copy of a work is sold, that the distribution right in that copy is exhausted, and so the person who bought it can resell it without any obligation to the rights holder. The resale right flies directly in face of that approach, because it's not in U.S. law, the United States certainly isn't interested in seeing it advance internationally. So it is it doesn't have a problem with it being discussed at WIPO, but it definitely doesn't want it to become part of the permanent agenda. And so I think with the U.S. opposition and the opposition of some other countries that don't have a resale royalty, we're simply not, it's not likely to ever become part of the agenda, the permanent agenda. Interestingly, members of civil society are sort of split on this issue. Certainly within the library community, I mean, this is not a library issue per se. I mean, obviously some libraries own these kinds of unique works of visual art, you know, paintings and lithographs and that kind of thing. But conceivably would not want to have to, conceivably would be impacted if they buy and sell those kinds of works, but it's still not a priority issue. And I think the views of people with respect to this sort of reflects their legal tradition. If they come from more of a common law tradition that is very focused on common law property rights, like the United States, they would see this as a strange doctrine that they would oppose. Whereas if they're more from a civil law and author's rights approach, they would be more welcoming of this approach. So there is time on the agenda, actually quite a bit of time, and it's sort of like with the PLR, that there's going to be a time for people to sort of the proponents to bring things up to speed, and then there will be a general discussion. Next, let me turn to the final issue we're going to discuss, which is a right for stage directors. This was proposed by Russia. The idea is to give directors of theatrical performances, so again, plays and so forth, the same kind of rights that the director of a motion picture might have. And the director of a motion picture is typically seen as the author, again, in many countries, as the author of the motion picture, and therefore has a copyright in the motion picture. And so the idea is to give similar protection to the director of a play. Different countries have different degrees of protection. Most countries don't give much protection of this sort. Part of it is because as a general matter, we're talking about a play or a performance, a stage performance, which isn't fixed, right? It's not recorded. It's just the live performance, and that could be something within the realm of related rights as opposed to copyright. but still, countries have difficulty. Different legal systems have had difficulty sort of giving any rights in this context, especially because it's not only is it not fixed, but because there are so many other people contributing to it. So even if the director directs the actor how they should perform a certain scene, once it's a live performance, the actor is sort of maybe following the direction of the director, but also might be doing his or her own thing, or making their own contribution. And so it's very difficult to sort of allocate rights. In any event, there has been so far very little interest in this approach and in granting international granting rights on an international level to stage directors, particularly in this SCCR, because it's a Russian proposal. It will get very little attention because of the invasion of Ukraine, and actually as an insult or a way of WIPO expressing its condemnation of the invasion, this issue on the agenda is only receiving 5 minutes. So I've probably spoken more about it just now than it will receive at the SCCR this time. So with that, I will stop, and we're happy to answer any questions you might have. Thank you very much.
Thank you, Jonathan and Teresa. I'm sorry I'm late. I was late due to technical issues, but it's a pleasure hearing you both. We have 2 questions in the Q&A panel. Both of them are from Kevin. So let me read the questions. So after these 2 questions, we can move to the roundtable. We have 2 minutes to answer. We are short on time. So one of the questions is, well, first is a congratulations for your presentation. I guess it's for Teresa. I would like to ask, how do you see the regulation for virtual libraries at the moment, weaknesses and strengths worldwide, and how do you think those regulations would be in some years? This is for clearly for Teresa, and the other for Jonathan is, it's a short one, but it's a really interesting one. Should NFTs have rather sweet?
Okay, so thank you very much, Beatrice. So thank you, Kevin, for your question. Well, I think the regulation of virtual libraries is done in a pretty much same manner as for physical libraries, in the sense that the material that's in a virtual library, like digital material, will be regulated by a license, generally by a contract. So whether it's, if the library has access to electronic resources in their library, they will usually, for commercial electronic resources, they will have a license from the publisher, and then that license will determine what the library can do with those resources, and whether they, to what extent the resources can be made available outside the premises of the library, or outside within that library network, or within the library consortium, or within the country. So I think in that sense, the regulation for electronic resources is usually by contract. So if that's what you had meant by regulations, and I think in terms of these regulations, these licenses, I think what's important and what the library community is advocating for is that the licenses don't take away the rights that we have under our copyright law. So if a library has an exception in their copyright law to make copies, or to share those materials for education or for research purposes, that the license permits also those uses and does not take away those rights, known as contract override. So I hope that's answered your question. Thank you.
And Kevin, that's a great question about NFTs. I guess NFTs, non-fungible tokens. So that's sort of this whole new concept where you use sort of like blockchain, and you're able to for a digital item, you're able to make sure that it is in fact unique, which is sort of contrary to general digital items, which can be reproduced infinitely with no degradation. So I would imagine conceptually, there's no reason why an NFT should not have a droit de suite, because it is a unique item. And so that, you know, given that, whether in a given country it would have droit de suite right now would really depend on how the statute in that country is drafted. And of course, in every country that has a resale right, it's drafted differently, so it may or may not apply to an NFT. But conceptually, if you do have an NFT, there's no reason for it not to apply, because the logic and the principle behind it would be the same. Thank you.
Thank you, Jonathan and Teresa. I will switch to Spanish para dar paso a la mesa redonda de gobiernos, que ya estamos, bueno, con 4 minutos de demora, así que voy a pasar la palabra a Luisa Suyay Torres, que es la directora general del Servicio Nacional de Derechos Intelectuales del SENADI en Ecuador, para que tome la moderación de la siguiente mesa redonda. Muchísimas gracias.
Muchísimas gracias, Beatriz. Perdón, perdón, estoy aún en la oficina. Muchísimas gracias, Beatriz, por darme paso. Continuando con el siguiente punto de orden del día, iniciamos con la propuesta de análisis de los derechos de autor relacionados con el entorno digital. Propuesta de Senegal y Congo.
Beatriz, disculpa, perdón, Luisa, ahora, cuando hagamos la mesa de funcionarios de gobierno, que te corresponde a ti moderar, las ONG y sociedad civil se retira. Así que ahí mi amiga Beatriz nos dio un salto muy rápido hacia ti. Entonces, si me permites un segundito para que nosotros, como sociedad civil, te agradecemos que nos hayas recibido en tu casa virtual de la Oficina de Propiedad Intelectual. También agradecemos a todos los funcionarios de gobierno y la Oficina de Propiedad Intelectual que nos han acompañado, atendiendo que nos interesa mucho el que podamos poder fomentar la conversación sobre estos temas que preparan en la agenda con total libertad. En este minuto cesa la grabación de este encuentro. Raúl, por favor, te